everyone, and welcome back to another YouTube video. My name is Rebecca and I'm an associate attorney here at Richards and Jerusik, and today we're going to be talking about national interest waivers and some recent trends we've been seeing. If you're a highly skilled professional, researcher, entrepreneur, or innovator whose work substantially benefits the United States, then the National Interest Waiver, or NIW, might be the opportunity for you. This is kind of a unique pathway that allows you to self-petition for a green card. That means you don't need a job offer from an employer in the US, and you don't need to go through that lengthy labor certification process. And that's what makes the NIW so valuable and appealing in today's immigration system. Now, the NIW is part of the EB-2 immigrant visa category. Unlike the traditional EB-2 applicants who need to go through that perm labor certification, National Interest Waiver applicants do not need to do that. But in order to qualify for the NIW, they need to show that waiving those requirements would be beneficial to the US as a whole. Now, before applying for the National Interest Waiver, you need to first qualify for that EB-2 category, and there's two pathways to do that. The first is having a US master's degree or higher, or a foreign equivalent, or a US bachelor's degree plus 5 years of progressive experience in your field, but you need to have that advanced degree. The second option is qualifying through exceptional ability. This does not require that degree element, but it requires you to show that you possess expertise well above the norm for those in your profession. Okay, so we're talking top 10% of your profession. Evidence for exceptional ability includes academic records, letters from employers, professional memberships, and evidence that you have contributed significantly to your profession, so contributions of major significance. Once that eligibility is established, you need to show that you meet the three-part test that was laid out in the Matter of Dinosaur decision. The first criteria you need to meet is showing that you have an endeavor that has substantial merit and national importance. This often includes fields like STEM, education, business, healthcare, and clean energy. And the work needs to have a broad US impact. It can't just be a local impact. The second requirement that you need to meet is showing that you are well positioned to advance your endeavor. That means, of course, having the right educational background, experience, achievements, and support. Evidence for this prong needs to include your degrees, of course. Patents are a great example, expert letters, grants, investor funding, and you need to show that you have a proven track record of success as well. It really goes beyond just showing that you have the education required. You need to show that you've been working in that field and have made contributions. The third prong is showing that on balance, it's in the national interest to waive those job offer and labor certification requirements. This requires some heavy justification. Favorable factors typically include urgent public need, unique skill sets. You are someone who has skills that very few people in the United States have. You should show, the potential for job creation in your field, and significant economic and societal benefit is another factor to consider for that. Now, USCIS tends to favor national interest waiver cases that support broader national goals, which include improving the economy, raising wages and working conditions, advancing healthcare or education, accessible and affordable housing, protecting the environment, national security. Those are kind of the main priorities of the national government. So if your endeavor falls within one of those areas, you can potentially present a strong case. However, as we move into 2025, the national interest waiver landscape has changed dramatically. So from 2018 to about 2023, national interest waiver approval ratings were around 90%. It was very high. But in fiscal year 2024, we saw a very sharp decline to about 43% success with these national interest waiver cases. And in early 2025 so far, we're continuing to see those trends. So approval ratings have gone down. So that's where it's increasingly important to make sure that you have enough evidence to support those criteria that we just discussed. But what's driving this change? Obviously, there's a very high demand for the national interest waiver because it doesn't require that perm process that can take years and years and years. It doesn't require that job offer requirement. And really, national interest waiver filings are making up almost half of the EB-2 petitions in this day and age. There's also a lot stricter standards. USCIS is demanding more detailed evidence-based petitions. Evidence is always important, but they're really cracking down on that. And that's evident by the amount of requests for evidence that they've been issuing. Almost every case that we've seen at least has gotten a request, and it's completely normal, but they want to see more. So keep that in mind if you decide to pursue this route. It's very evidence heavy. But what does this mean? So the national interest waiver is no longer considered the easy self-petition option to get you a green card. Success now depends on having exceptional documentation, strong letters of support. That's huge. And making sure you have a clear and compelling argument that clearly lays out what your endeavor is and how your work serves in the national interest of the United States. So if you're planning to file one of these applications, take the time to build a strategic and well-supported case. If you think that you may qualify for the national interest waiver or have any additional questions, please feel free to reach out to our firm at any time, and we are happy to help.